SJC-12497, DR Peck Excavating v. Jose Machado.
Mr. Zajac.
May it please the court. Good morning, Your Honors. John Zajac for DR Peck Excavating. On your first day back in this session, we're here on a small claims matter, and I find that interesting. We're here because if the jury in this case had found for Fence Choice Incorporated against DR Peck Excavating Incorporated for breach of contract in the amount of $6,250, there'd be no reason to be before you. But that's not what happened here, and we're before you on 4 issues. One is with regard to the parties and the failure of the trial judge to allow a motion for directed verdict with regard to those parties. The undisputed evidence at trial was that a fence was installed by a corporation known as Fence Choice Incorporated, and it was at the alleged request of a corporation known as DR Peck Excavating, Inc. However, when Mr. Machado brought his small claims action, he brought it in his own name, and he brought it against David Peck as the owner of DR Peck Excavating without any reference to its corporate status. Mr. Peck moved for a directed verdict at the close of the evidence, at the close of the defendant's case, and after the jury verdict on a JNOV, and all of those were denied. However, the undisputed evidence was that neither of the proper parties were before the trial court. Nevertheless, the judge denied Mr. Peck's motions across the board, and we believe that that was an error that this court now needs to address. You'll see that we had endeavored to bring this, we had requested a report of the case from the trial judge to the appellate division of the district court, which he also denied, which is what brings us to the SJC rather than to the appellate division, as we believe that the appropriate remedy would have initially been under the Arisian and Hall case under Chapter 218, Section 23, for it to go to the appellate division, but the judge denied to, declined to report the case. The second issue...
You had the chance to get out of small claims court and go to district court, but you didn't exercise that privilege.
That's true, and I'm sure at the time no one expected that we'd be standing before you a year and a half later. As you'll note from the docket, there was initially a default judgment that was vacated in the district court, and it seemed, I would suggest it would seem like piling on to then, after having indulged the court in vacating that default judgment, although Mr. Peck denied ever receiving notice of the case, to then bring the case to the regular district court and out of the small claim session.
But is there not consequence? I mean, by doing that, you limited Mr. Machado to $7,000 in terms of damages, so there were benefits for you in terms of how much you were at risk?
I suppose there were, but he was not claiming damages even in the amount of $7,000. He was claiming damages in the amount of $6,250. There was no counterclaim. I don't believe the defendant believed there was any necessity for discovery or the other things that would have been available. But hindsight is always 20/20.
Okay, but isn't there a consequence to your doing that? That you're basically are now in the more limited realm of appellate review that comes with a small claims case?
That's correct. That is the price that one pays.
So why do you say you should not pay that price?
Well, we're asking for that appellate review from this court, which is our last recourse that we have in this matter.
But if everybody else doesn't get it, why do you get it? If we set up a system of small claims to resolve these issues without traditional civil appellate rights, and you choose not to transfer your case, how come your appellate rights aren't limited like everybody else's?
Well, again, the appellate rights that were limited were then triggered by the trial judge not reporting the case to the appellate division. There still is another method of appeal, but it falls entirely within the hands of the trial judge as to whether or not it can proceed to that next level, unlike most other avenues of appeal.
But isn't it the single justice's actions that we're kind of reviewing here, not whether what the other
Ultimately,
judge
it
did?
is. Ultimately, it is. That's
Why
correct.
do you say he denied his discretion?
For all the reasons,
Discretion, I'm sorry, abused his discretion.
correct. For all the reasons that we argue in our brief, why the trial judge should have at least reported the case to the appellate division. The arguments with regard to the improper party, the quantum merit,
Have an alternative remedy?
not once he did that.
No, not once the single justice acted, but when the single justice was acting, did you have an alternative remedy?
According to the trial court, no. That's why we proceeded in this fashion. When we went to the trial court, they specifically told us that there was no redress going to the appellate division.
Did you try?
Not once the trial court told us that, no.
Well, how do you know that that wasn't an alternative remedy?
Because at that level, there's no way to get it to the appellate division. It's the trial, the district court has to then report the case to the appellate division for us to get it there. We did what the court told us to, which was to bring it here.
So where's the injustice? Mr. Machado, you agree, did build this fence.
He built a fence, but not for Mr. Peck. He built a fence for a property owner who got the benefit of that fence with no evidence, and because there is none, that Mr. Peck derived any benefit from it.
Was there an agreement between Peck and the landowner?
There was an agreement between D.R. Peck Excavating, Inc. as a subcontractor to a contractor doing work for the landowner, but not to build a fence.
Oh, okay. But not to build a fence. What was it for?
It was for general site work, sidewalks, foundations, things like that. He was asked to get a quote for a fence, which is all he thought that he was doing.
What work did Mr. Machado do?
Mr. Machado installed fence posts, but not an entire fence.
Kind of like groundwork.
Well, because the evidence at trial was undisputed that Mr. Peck saw him installing the fence posts and said, "What are you doing? Stop." And so that's where the work stopped. He installed the last 8 out of 150 fence posts when he was seen by Mr. Peck installing fence posts.
After doing 150 of them?
148. It was 2 days' work, and Mr. Peck was not always on the site.
But the actual judgment is against D.R. Peck Excavating, Inc., not against him.
No, it's not.
But it says the petitioner appeals from a judgment of this court, so
The judgment itself does not say Inc. The small claims complaint does not say Inc. There's no corporate references in any of the pleadings in the district court.
who is your client?
David Peck, purportedly owner of D.R. Peck Excavating, but is in fact a corporate defendant, which is what the evidence at trial showed. He testified to it, Mr. Machado testified to it, and
When you say testified to it, meaning?
he admitted the articles of organization for his corporation and business. He showed the subcontract that he had with the general contractor in the name of his corporation, and even Mr. Peck said he was dealing and had dealt with D.R. Peck Excavating, Inc., and in his capacity as Fence Choice, Inc., not personally, which was the exact basis for the directed verdict.
And did the magistrate have the ability to reform the complaint in light of the evidence?
He could have, but he did not. I guess he could have suggested to the parties that they agree to an amendment or that Mr. Machado move for an amendment, but that didn't happen. And there's now a judgment against someone who both parties testified was not the proper party to the case.
But your petition under 211-3 is in the name of D.R. Peck Excavating, is it not?
It is, because that's who the judgment is against, even though David Peck is a person who is an officer of a corporation that was not named, but who undisputedly was would have been the proper party. That's what the evidence at trial showed, and yet no directed verdict entered.
All right, thank you.
Thank you very much.
Mr. Machado? And you're there with your
Good morning,
spouse?
Your Honor. My name is Joe Machado. I'm the owner of Fence Choice. DR Peck Excavating, the fight that he's talking about, the name and all that, never existed in the first trial. There was nothing to do about that. It was just whether he hired me or not. So I don't, but to make a long story short, they called me. They showed me the layout at the playground, about 150 poles or so. And I was just about done on the last 5 poles or so. I ran into Mr. Peck. He says, "Hey, what are you doing over here?" I says, "What do you mean? Your company hired me to put all these poles," showed me all the layout. I met with Tyler Steek, who runs that company at the time. And so I says, "Well, they're going to get their own fence company to string up the wire and stuff." So I says, "Okay, what do you want me to do right now? You want me to finish the last 5, 7 poles, or you want me to just stop right now?" So he says, "Well, finish cementing your 5, 7 poles I had left." He says, "And bill me for whatever you did." And that's what I did. And I billed them to DR Peck Excavating and to pay it to Fence Choice. When I went to the first court, I'm not a lawyer, it said name, I put my name, Joe Machado. I'm the owner, president of Fence Choice. And then we had that trial, and then we went to the jury trial, which I'm not a lawyer, I represented myself.
You won both of them.
Yes, and I don't, and the judge, prior, without the jury being there, advised me, says, "It's very difficult for you. You're gonna have to prove that this was a verbal agreement," which 90% of my work, I've been doing this 40 years, this is my first time I've ever sued anybody, is through verbal agreements. I've learned something. After 40 years, you still can learn something. To be a little bit more careful. I've done a job for this company like a year prior at Bridgewater State College. They called me up and they told me, the same guy, Tyler, showed me the job. Okay, told me when I could do it, went there, did the job, and I got paid within like 30, 60 days, fine. This company here, DR Peck Excavating, not looking at the paperwork, I chased him for over a year. He kept saying, "I'm gonna pay you in a month, 2 months, a month, 2 months. And it was such a hassle. And after about a year, I met him at his place of work, DR Peck Excavating, and he's trying to get the money from the architect of the project, which he couldn't get a hold of him for a day or 2 or 3. Finally, I called him up after 3 days because he couldn't get a hold of him at his office. He says, "Oh, when I get a hold of him, I'll give you a call." And I'm like, after a year, shouldn't we have done this the first day when I billed you? So after those 3 days, I called them. Tyler gave me the number. I called. They answered the phone instantly, the head person, and he explained to me that the DR Peck Excavating signed a waiver that they paid all the subcontractors that worked on that job site. He left you out. So he says, "Your only thing now is take them to small claims." That's what I would do. I says, after a year, then I went to small claims. I chased him for another like 6 months in small claims. Couldn't get a hold of him. His address is right there, his work. He was just not answering the call. I had to get a KPS against him. And finally got a hold of him after a while. And this is where we're at.
Did you got a $7,000 judgment in
Yes.
small claims, right? How much were you owed, actually?
I think it was $62.50. And the judge told the jury that he's suing for,
What was your bill for?
I think it was $62.50.
$62.50?
Yeah, but he added other court costs like interest for like 2 years and a bunch of other things. But the judge told the jury that he's suing for $62.50, max is $7,000. And they came back within 20 minutes, 30 minutes after the trial and said $7,000. And he offered the $7,000, DR Peck Excavating offered to pay $7,000 after the trial. But because I've been chasing him over 2 years, I says, I've wasted so much time and energy with this, it became a thing of principle, honestly.
Do you, the amount of time that you've spent working on collecting the money, has that taken away from you earning other money?
Oh, my God, that is such a good question. That is such a good question, thank you. If I had to do this all over again, honestly, the money that I've lost, I don't think I would do it. And I think that person's DR Peck Excavating, he knows the system. I do not know the system. I know it now, but I didn't know it before, and there's no way I could do this. You know, the company is whole shut down. We have like one crew, and I have to be there at all times, showing jobs, doing estimating. I got to do everything, and I couldn't do it.
You may have a second career as a lawyer, though. You're batting,
Oh,
you're
no.
batting almost 1,000.
Oh, no, I don't. No, I don't. You should have seen me at that trial. I didn't even know we had to pick a jury. I'm over there like, we got to pick a jury? How do we do this? So I told Mr. Zajac, pick whoever you want.
they
The judge
still
says, hey, you
lost.
can kick people out that you don't like. One of them
But
was
you
his
have a
neighbor.
better record than some of the trial lawyers
One
here.
was the guy's neighbor. And they're the ones that wanted to throw him out. I says, I'll leave him on. He's okay. His neighbor. So I'm like, this is getting really unbelievable, you know? But I'm sorry about, you guys got more important things to do than this. I mean, this is unbelievable. You know, I never thought it would get to this point. You know, I apologize for taking up your time, and it wasn't also, it was the principle, and seeing, where's this going? I mean, is there a stop to this somewhere down the line? And I hope today is the day that we stop it. I mean, is there another place that we can go with this? I don't want to go to Washington. They're more on the mess than we are.
Okay, thank you, Mr.
Sometimes, you guys got any questions?
I think we've asked whatever we need, so thank you, sir. And
Really?
again,
Oh, I
you don't
hope I
need
didn't
to
bore you guys.
apologize for us. We hear cases before us, and yours is a case before us. Thank you, sir.